Let's roll, nerds.
Alex.
Excused?
Oh.
Yes.
Okay. The beauty about trial, also the most unnerving thing about trial, is you never know what kind of witness you're going to get. When I tried cases before as a, on the other side, there's two things. You never know how a witness is going to testify. Number one. Number two, you never know how juries will react, what's going to make them happy, what's going to piss them off. And it could be the most minute thing that you would never even think of that just really irks them in such a way that goes against you. So that's what I'm trying to tell you is you never know what kind of witness you're going to get. Even if you prep your witness, it's a completely different thing when you get on the stand, because if you've never been on the stand, I have before, because I had a defense lawyer put me on it to testify in a rule invocation problem. I was sweating bullets. I was nervous. I was a wreck. So as you can see, when she was testifying, it's tough. It's not an easy thing. So with that in mind, let's go on the record. I'm going on the record.
Now pause here. Notice how the defense immediately goes for a motion to suppress the detention. This is huge. If they can convince the judge that the initial stop was unlawful, then everything that follows, the evidence, the testimony, even the admissions, could be tossed out. It's like pulling the bottom card out of a house of cards. Without it, the prosecution has no case. Question for you. Do you think the defense is smart for aiming big this early? Or risky because if the IAA judge shuts this down, it could weaken their entire strategy?
You wanted to say something?
I'd like to move to suppress the detention for it being illegal and just recite what we know so far. The 911 caller from Sonic stated that they did not give any physical description of who was driving, stated that there was a man and a woman in this vehicle, stated that there was that they damaged their mirror by running into the drive-through, and they turned left out of the restaurant. Officers, well, she didn't say it yet, but she went the other direction, and she even, they state that on a...
And here's where it gets messy. The officers originally wrote in the probable cause affidavit that they saw the defendant exiting the vehicle, but when questioned, both admitted they actually didn't. That's a big credibility problem. In court, the smallest contradiction can turn into a gaping hole in the prosecution's case. Was it sloppy reporting? Or a convenient adjustment to make the arrest look stronger? Either way, the defense now has ammunition to argue. If they got this detail wrong, what else did they bend? What do you think? Is this a fatal flaw or just a paperwork mistake?
So they ran the license plate, and on a hunch, they went to, here's kind of the full story. She did have previous encounters with him, and she said on a hunch, when they saw that plate came back to him, they went directly to where they know he lives. And they wrote in the probable cause affidavit, they saw him exiting the vehicle, which is not true. And there's an interview with the state, with Alex, where he talks to both of the officers, and they both say, no, we did not see him exiting the vehicle. So we have that problem of no identification whatsoever. She couldn't identify him in court from the Sonic call. But then they go to his house, and
To his house?
they go straight to his house. They don't even go the direction the Sonic person said that the vehicle left. They go westbound. The vehicle was reported to have gone eastbound. She drives over to his house because there's history, and he said that they've been to his house before. They mess with him. They mess with people that are over there. That's kind of, they knew him. But she wrote that in the
hearing right now.
No.
She wrote that in the probable cause affidavit too, that she has encountered him before, and she.
This is the heart of the issue: identification. No one can say under oath they saw the defendant behind the wheel. Without that, proving he was the driver is like proving someone committed a crime without a single witness. Yes, circumstantial evidence matters, but jurors are human. They want certainty. They want, I saw him. Without that moment, the defense can hammer reasonable doubt. Think about it. Would you convict someone of DWI without a single witness to them actually driving? Or is circumstantial evidence enough for you?
Knew him to be an intoxicated driver, for what it's worth. She wrote that in the PC affidavit. That's why she went to his house when she got the name. But she said, I never saw anybody behind the wheel. There was only one person in the vehicle, and the reportee said there were two. They were able to, never saw anyone behind the wheel, observed a vehicle. Was there anyone in the vehicle when you approached? She said no. She said it was off. And then asked if he had keys to the vehicle. She said, I can't remember. No identification of him. Oh, and here's the other piece of information that is really important. If there was going to be some other evidence that he was operating or that was the truck, look for the damage on the mirror. They do that.
My only concern
There's
now.
no damage though.
Concern now. Do we have a witness that sees him driving?
I mean, obviously that's a lot to respond to. I'll just take it about the issue that's at hand, right? Wheeling the defendant, okay?
I don't care about all the extraneous crap. I don't care. My only issue now, because really,
I'll let you the judge. We're relying on the basic premise that the law does not require absolutely a person watching the person behind the wheel. They can still be wheeled, legally speaking, sufficiently through other means, both through an admission, their own admission, and then through other circumstantial evidence. We're getting in both the admission of the defendant who admits to
but
driving.
you can't get to the admission.
That's what I'm saying is we've got to lay the groundwork there in order to get let the officer testify to all of what she saw, all of the things that Tyler's bringing up. Some of them are partial truths, and maybe they're worthy of being impeached on. Maybe not. We're going to let her testify. The jury should be allowed to hear her testify and decide what is credible and what's not. She's going to testify to what she saw, and she's going to make it very clear that there's literally no one else that could have been driving the car. There's just not. Same thing as if a person comes on an accident in the middle of the road.
There's still a hunch. It's a hunch. Sure.
She's going to testify that she watches the car drive up into the driveway. She's going to testify to you that she watches a male get out of the vehicle. She's going to testify that she doesn't lose visual contact with that person. She's going to testify that she watches the brake lights go off. She's going to testify that this woman that was talked about is there. She's on scene. Tyler's aware of this. I know he's aware. He's read the OR. She's sitting on the porch of the house, right? So she's going to, if given the chance, she's going to testify to all of this. This will lay the groundwork to get in at least her body cam when she speaks to the defendant, and you can hear from him himself about what he was and wasn't doing. He'll make plenty of statements on that.
You said there could be nobody else possibly driving, and now you're saying there's another woman at the scene.
Already there when the car pulls up, Tyler. She's on the porch.
Not according to the Sonic people, though. She said that there were two people in the car.
I understand that.
Didn't give any physical description. Could not identify him in the courtroom after 7 times asking.
So listen, the Sonic is why the officers begin. I'm not finished. The Sonic is why the officers begin investigating.
They saw him driving.
You can't talk when he's talking. I can only take one.
Tyler,
I'm sorry.
let him finish.
Sonic is why the officers initially investigate the defendant. That's clear, right? There's the 911 call, even though she was unable to state that she recognized the person in the vehicle on the record. She calls 911, she gives a description, she gives the license plate of the vehicle that she saw with the person driving and that ran into the Sonic. Police get the dispatch, they run the license plate, they recognize the person. They go to that person's residence.
And there's the problem.
Why?
They recognize and they assume who that person is. There's two people in the car. They're making an assumption.
She said that there was the witness just said there was a male, an older white male driving.
Your Honor, if I may, the 911 call does not identify who's driving. So she doesn't know who's driving when she gets dispatched. She doesn't know if a man or a woman's driving. If we listen to the 911 call, she just says there was a man and a woman in a vehicle.
And she writes on a hunch.
I don't think it survives a directed verdict. I don't.
So I don't want to waste the court's time, Judge. We're going to get testimony from the officer about all of the circumstances of what she did and didn't see. She's not going to testify that she saw this defendant specifically behind the car.
I don't think it's relevant.
Okay, so then is it the court's position then that based on the testimony and your rulings on the evidence thus far that you wouldn't allow in the remainder of the testimony such as body worn camera? Okay, then I'll follow.
Sorry.
I'll dismiss.
Yes, Your Honor.
All right. That's it.
So a motion to suppress the detention.
Thank you.